So in 1996, passed by Congress and signed into law by President Bill Clinton, the Defense of Marriage Act made sure that for purposes of federal law, the words marriage and spouse would refer to only refer to legal unions between a man and a woman. Um, in the time intervening between 1996 and when this case is decided in 2013, a number of states had authorized same-sex marriage. And the federal government, because of the Defense of Marriage Act, refused to recognize those individuals as married. The particular instance in this case involves around a widow by the name of Edith Windsor, who was the sole executioner of the estate that was left to her by her spouse. The individuals were married in Canada, but that marriage was ultimately recognized in New York. And so it is as though the state of New York sanctioned said marriage. When Windsor's wife deceased, she left the entire state to Windsor. And because that their marriage was not recognized by federal law, the government imposed over $350,000 worth of taxes upon Windsor. Had their marriage been recognized, absolutely zero taxes would have been imposed. So Windsor filed suit claiming that the Defense of Marriage Act was unconstitutional. So there are a few issues in this case. I'm actually only going to deal with a couple of them. Well, actually, I'm only going to deal with one. Does the Defense of Marriage Act deprive same-sex couples Thank you, honey. Does the Defense of Marriage Act, and I might sneeze again, hold on. Okay. Does the Defense of Marriage Act deprive same-sex couples of their Fifth Amendment rights to equal protection under federal law? So the difference here is we've been dealing almost exclusively with 14th Amendment equal protection and 14th Amendment due process. But because this is a state, or this is the federal government, we have to deal with the Fifth Amendment because the 14th Amendment does not really regulate the federal government. So in a very close 5-4 decision, the Supreme Court, with Justice Kennedy again writing the majority opinion, says yes, yeah, it does. So it has to be unconstitutional, at least in the eyes of Justice Kennedy, because it ultimately treats similarly situated people differently, but also because it undermines notions of federalism. States are the ones who get to play a role with regard to whom is married legally and whom is not. And the federal government, vis-a-vis the Constitution, doesn't have much of a role to play. And so by the federal government acting in this area, they don't overstep the bounds of their confines because they defined marriage federally and allowed states to do it their way. But it still impinges upon the notions of federalism, where the federal government doesn't regulate in areas where the states have exclusive jurisdiction. Furthermore, it's a violation of the Fifth Amendment's notions against protections against due process and equal protection. And the reason for this is because it takes two differently situated classes of people and treats them systematically differently. And the only thing that separates Edith Windsor from any other widow was that she was widowed by a woman and not a man. And within the understanding of the state of New York, she was legally married, and the federal government's choice to not recognize that marriage, but recognize the marriages of everyone else in the state that were opposite sex couples, is a violation of the Fifth Amendment. Individuals in dissent, again, Chief Justice Roberts, Justice Scalia, Justice Alito, and Justice Thomas. Their dissent, functionally, sounds very familiar to the previous dissents we've heard. Justice Roberts doesn't so much deal with the issues of the Fifth Amendment and whether we witness a violation there, but he simply deals with the fact that there's no jurisdiction of the court to hear this case, so we're going to put that aside. Scalia does deal with the standing issue as well, which again I'm putting aside, but he also answers the merits question. He argues that the majority opinion doesn't need to get into whether the strict or rational scrutiny basis question is here, because it says it's a violation of basic due process, and so he's not sure why the court is weighing in on that. He believes that under rational basis, this law would hold up. And he argues that some might believe that he again, Scalia writing is interesting. He writes, some might conclude that this loaf could have been used a while longer in the oven, but that would be wrong. It is already overcooked. The most expert care and preparation cannot redeem a bad recipe. The sum of all the court's non-specific hand-waving is that this law is invalid, maybe on equal protection grounds, maybe on substantive due process grounds, and perhaps with some amorphous federalism component playing a role, because it is motivated by a bare desire to harm couples in same-sex marriages. He argues that there's nothing in the majority opinion that is clear, exacting, or controlling. And all of this is because, in the majority opinion, nothing is pointed to very clearly as controlling. There's a discussion of equal protection. There's a kind of a discussion of substantive due process. And there's this federalism component layered over the top. But what Scalia gets right is that none of that is all very clear. And while Kennedy writes a persuasive, elegant, moving decision, it's not a good legal decision, because the grounds on which DOMA is overturned or DOMA is struck as unconstitutional is not very clear. And he provides another foreshadow. He again says that after the decision in this case, same-sex marriage is the next thing that this court will consider. And if this court doesn't change, same-sex marriage will become the law of the land. And he's right, because it does.